Can a DWI be reduced in NY? Getting charged with a DWI in New York is a serious matter. But in some cases, the charges might be reduced to a DWAI. Knowing your rights and having the right legal representation can make all the difference in how your case is handled. DWI cases carry major consequences in New York. A conviction could mean jail time, heavy fines, and a suspended license. But not every DWI charge leads to the harshest penalties. That's where legal defense becomes essential. Working with a law firm that understands the New York court system and has experience handling these cases could improve your chances of a better outcome. New York law treats DWI and DWAI differently. A DWI, or driving while intoxicated, is a misdemeanor and a criminal offense. It involves operating a vehicle with a blood alcohol content of 0.08% or higher. A DWAI, or driving while ability impaired, is an infraction, not a crime. Though it still carries penalties like fines and possible license suspension, those penalties are significantly less severe than for a DWI. Prosecutors and courts view the distinction seriously, and understanding that difference is crucial if you're hoping to reduce your charges. Reducing a DWI to a DWAI often involves a plea deal. Plea deals aren't guaranteed and usually depend on factors like a clean criminal record, a low BAC level, and no aggravating circumstances such as property damage or injury. If it's your first offense and the evidence against you is weak, a lawyer may help you negotiate a reduction. The process typically starts with the attorney reviewing all evidence, including breath or blood test results and arresting officer testimony. If any part of the evidence is unreliable or obtained improperly, it can be challenged in court. Your attorney might also show that you weren't actually operating the vehicle or that the vehicle wasn't on a public highway, both of which could affect the charges. Another potential reduction in New York is having a DWI charge downgraded to reckless driving. This is less common and harder to achieve. It typically depends on the strength of the evidence and requires the district attorney to be convinced that the original charge isn't fully supported. A skilled lawyer may use legal motions to get certain evidence thrown out, strengthening the case for a reduction. Prosecutors evaluate several factors when considering plea deals. These include your criminal history, any harm caused during the incident, your BAC at the time of arrest, and whether additional charges apply. They also look at the strength of the state's evidence. Prosecutors aim to balance public safety with appropriate consequences, and they use this information to make their decision. Getting a DWI charge dropped entirely is challenging but possible under specific circumstances. If law enforcement lacked reasonable suspicion to stop your vehicle, or if they didn't have probable cause to arrest you, your lawyer could argue for dismissal. If officers didn't follow proper breath test protocol or can't prove you were operating the vehicle, these can also be grounds for getting charges dropped. An arrest doesn't mean a conviction. Your defense strategy and the experience of your legal team are what truly matter. Working with a law firm that knows the prosecutors and judges in your county can also be a major advantage. Familiarity with local legal processes allows your lawyer to build a more tailored defense. At the law offices of Jason Bassett, PC, our team understands what's at stake. Whether you're hoping to reduce a charge to a DWAI or fight for a full dismissal, we can help guide you through the process. To get trusted legal guidance and increase your chances of a better outcome, contact the law offices of Jason Bassett, PC today at 631-259-6060. Our office is located at 320 Carleton Avenue number 4200, Central Islip, New York, 11722, United States.